Good morning, everyone. Welcome to another edition of Critical Conversations, where we talk about hot topic issues related to the Muslim world. Today, we shall talk about what lies in store for American Muslims under the Trump administration. What are the prospects of a Muslim registry, the legal precedent regarding internment camps, and expanded surveillance of the American Muslim community? To help us explore these questions, we are joined today by Professor Sudha Setty. She is the Associate Dean for Faculty Development and Intellectual Life and a Professor of Law at Western New England University School of Law in Springfield, Massachusetts. She teaches law and terrorism, comparative constitutional law, civil rights, business organizations, and contracts. She was awarded the Catherine J. Jones Professor of Year Award in both 2009 and 2016. Her scholarly work focuses on comparative analysis of separation of powers, rule of law, and national security issues. Professor Setty's recently completed book, National Security Secrecy: Comparative Effects on Democracy and the Rule of Law, will be published by Cambridge University Press early in 2017. Professor Setty graduated as a Harlan Fiske Stone Scholar from Columbia Law School and received her BA in History with a concentration in Comparative Civil Rights with honors from Stanford University. Professor Setty, thank you so much for being here.
Thank you for having me.
So let's begin with the proposed Muslim registry. During the election cycle, candidate Trump repeatedly spoke about the need for a Muslim registry where all Muslims living here in the US would be required to register. Since the election, the spokesman for the Trump transition team has sort of backed away from that position, but members of the team, the transition team, keep bringing the prospect of a Muslim registry up. So we really don't know what will happen after the inauguration. However, if the Trump administration decides to go ahead with a registry, will it be able to do so legally and constitutionally, and what will some of the implications of that be?
Yeah, so these are good questions. I think you highlighted an important point that there is a tremendous amount of uncertainty with what the Trump administration will do on a whole host of issues, and this is certainly one of them. I think in the first instance, the likelihood of an actual Muslim registry along the lines of what we've seen historically in other countries, people talk about Weimar Germany as one of the examples of this with the Jewish population there. I think that is unlikely. I think that the campaign rhetoric about registering Muslims, even at the time, if you look at the transcripts, it's bandied about, that kind of language. But it's unclear if that's a commitment that candidate Trump back then was willing to make. It seems now that perhaps calmer and more rational voices are prevailing to suggest that that won't be something that he pushes forward. I think if he did, right, in the very unlikely event that he does suggest this is something that he wants to do, there would be a tremendous number of issues that would come up with that. And I would see them falling into three categories. The first issue would be the legal issue, that it would be immediately challenged, right, by anybody who has standing, meaning they feel like they've been personally impacted by this. So anybody who would need to be registered under such a proposal would immediately have standing to go to court and say to the judge, please put a stop to this before it starts. It's unconstitutional. And I think they would have a pretty good grounds for arguing that it's unconstitutional, and we can talk about that more if you'd like to. The second issue, I think, would be a pragmatic challenge. How on earth would you go about organizing a Muslim registry? Would you do it by people's surnames? That seems like a very inexact science, given the number of people who are Muslim whose names do not read as traditionally Muslim.
Sure.
Representative Keith Ellison is one good example of that. And then the number of people who would, as activists, register themselves, even though they're not Muslim, just as a sign of solidarity or being an ally of the Muslim community. And there's a question of what you would do with that information once you have it. It seems very unwieldy. It would be inaccurate. It would be both over-inclusive and under-inclusive. What utility would this information have? And then I think the third challenge is just a general political challenge. I do not think, unlike many of the other proposals that the Trump team has talked about, that there's a lot of political support for the idea of a Muslim registry. It may be that members of his transition team have mentioned this, but I have a hard time imagining most of the political elites, either in Washington or on the state level, be supportive of this idea or willing to help effectuate it. So I think that there are a number of challenges to this if he were to want to go forward with such a proposal.
Sure. And so you mentioned the constitutional grounds, under which it would be challenged. And how would that be? And what would be the method if they do want to go ahead and institute it? Would it happen through an executive order, or what would be that process?
Yeah. So we could imagine an executive order coming. This is there's precedent for that in terms of during World War II with the Japanese internment camps. That initially came through an executive order 9066. It's kind of an infamous executive order at this point. And it was issued in the name of national security, saying, I'm the president. National security is an area where I have a lot of natural power vested within me constitutionally. So I'm going to use that power to issue an executive order. So I think that that's the most likely way that that would occur. Once that order is issued, as I said, anyone who is affected by that order would have standing to bring a case in court saying this is unconstitutional. And they could do so on equal protection grounds. They could do so on due process grounds. They could do it on First Amendment grounds and freedom of religion. There are a lot of different ways in which you could potentially challenge such an executive order. And the unfortunate history with this is that when, in the context of World War II, that executive order was issued for internment, that was actually validated by Congress and by the courts, and frankly that a majority of the American public at that time was supportive of the idea of internment, again fearing that there was infiltration coming within the Japanese and Japanese American communities in the United States. I don't think you have the same level of fear in the general public at large. I think that there are much more rational and calmer voices in politics, in the activist community, and in the public at large to suggest that there would not be support for this. I have a hard time seeing courts necessarily validating that kind of decision making. I think out of the 8 justices currently on the Supreme Court, 7 of them have openly said that they believe that Korematsu, which was the court decision validating the Japanese internment, that they think it was a terrible decision. And some of them have described it, and this is across their political spectrum, as one of the worst decisions in U.S. Supreme Court history. Justice Thomas is the only one who said that it's still good law out of the 8 who are there. And so I think I have a hard time seeing the judiciary kind of collapsing the same way that it did in World War II in terms of enforcing this kind of civil right and human right question.
Sure, and we'll come back to Korematsu versus the United States sort of a little bit later on. But and you mentioned this, that there are lots of civil society organizations that have come forward and come forth in solidarity with the Muslim community, saying that we will all register if this were to happen. But do you think that would be an effective way to undermine that policy, or would the government still be able to sort of vet people despite having wholesale registration?
See, one of the reasons I think that registration is practically, I think it's, just to be clear, completely wrong-headed on a number of grounds, but even if you were to go down the road of suggesting that there needed to be additional scrutiny or some sort of additional check on a particular community, I would think that a self-registration process would be one of the least effective ways of doing that. There's been a lot of evidence over the last 15 years of the federal government gathering a tremendous amount of data on Muslim communities already. They've done it through memberships in mosques, memberships in Muslim student groups on campuses, a variety of other ways in which they've built up a lot of information about people. The step of actually overtly registering a group of people, I think, is more of a matter of political theater than it is a matter of effective national security policy, again, even if you believe, which I don't, that this is the road that you want to go down. So to that end, it seems like the efforts of civil society groups to undermine the registry, I think, would probably be effective in the sense that you would get too much data, and it wouldn't be that easy to sort it out. It would be kind of like after it became clear in 2005 and 2006 that the federal government was surveilling Muslim communities in very particular ways, and there's some evidence of the FBI and other organizations looking at the photo albums online of various people and the Muslim activists, that they started taking pictures of everything, right? And saying, okay, if you would like to look at what I'm doing, here's 7,000 pictures today that you can look at.
Right.
And the idea of civil society organizations registering all their members, whether Muslim or not, or
Yes.
encouraging their members to do so. It's a similar idea of saying, okay, you want this big haystack to look through? We've made that haystack even bigger for you.
Right. Sure. So, I mean, it would be very effective in that respect.
It might be.
It might be. And so, a lot of people sort of confuse this proposed Muslim registry with the NSEERS program, and which is the National Security Exit Entry Registration System that the Bush administration had put in place right after 9/11. And that sort of was a check on people who were not citizens coming into the U.S. or living here as non-citizen visa holders from 25 different countries, 24 of which were Muslim majority countries and North Korea. And they had to sort of check in with immigration officials every few months and everything. So when people hear about a Muslim registry, they say, well, it was already in place. It was discontinued in 2011 for being ineffective, and sort of because of various civil rights organizations had a huge problem with that. But this would be a different thing. What the Trump administration or the transition team has been talking about is that different from NSEERS, or is this sort of along the same lines?
So that's a good question. And, again, reading carefully what they've said, it's unclear exactly what the scope of what they're envisioning is. It seems more practical to suggest that they would reinstate NSEERS, that would be the type of program that they would look to reformulate. And it would be a much easier program to reformulate, in the sense that they could use the same kind of legal and administrative framework that was in place during the Bush administration and the early part of the Obama administration for NSEERS. They could readily make the argument that because these are non-citizens, there is much greater discretion for the executive branch to decide how they want to handle people who do not have the full benefits of U.S. citizenship. And the NSEERS program was insulated in a lot of respects from legal challenges. First, because it was secret for some period of time, and then after that, because it was dealing with an immigrant population that were non-citizens. NSEERS was discontinued, I think, and you mentioned this, because it was incredibly ineffective, right? It was very costly, it was very resource intensive, but at the same time, of the people that they had tagged for removal under NSEERS, not one of those 13,000 people were ever convicted of anything related to terrorism, right? Some of them were convicted for other things, credit card fraud, were a few cases. There were people who had committed abuses with overstaying their visas or doing other things. There was some other kind of petty theft. There were some violent crimes that were not related to terrorism. But again, not one of them related to terrorism. It was an incredibly ineffective program. So they could, again, choose to resurrect this because of the kind of political theater and the value maybe to the Trump supporters of fulfilling some aspect of this campaign promise that he had made. I think that there would be a lot of legal challenges to that now, too. I think, again, there's been a lot more knowledge and activism among legal groups. There are a lot of legal groups that have already talked about the idea that if NSEERS is resurrected, they will start deploying lawyers to do work for those who end up on the removal list or going through removal proceedings. So I think that that would be a much more likely scenario, but that there would still be a significant amount of resistance to that.
Sure, but then NSEERS, while it was sort of in place for about 9 years, it was never deemed unconstitutional. How would you judge it on constitutional grounds, given that it was sort of directed at non-citizens?
So here's where the president has much more leeway than he would with a Muslim registry. NSEERS was never characterized as anything having to do with the Muslim population, right? It was characterized as a national security program geared at individuals from particular nations. As you pointed out, 24 of those 25 nations happen to be ones with Muslim majority populations. But on its face, it was characterized simply as a national security initiative. It was not based on religion on its face. We can all perhaps infer from how it was structured and run that religion was one of the reasons why the NSEERS program was constructed and run the way it was. But again, it was considered facially neutral. So under those circumstances, and because we're dealing with immigrants, we're dealing with a facially neutral national security related initiative dealing with immigrants. Those categories of action are ones in which the president constitutionally has a lot of leeway. So for national security matters, a lot of leeway. For immigration, a lot of leeway. And once those things are facially neutral, there's going to be less grounds for any kind of constitutional challenge to it. One of the things about Trump actually coming out and saying, a Muslim registry or members of his team saying that, is that it's no longer facially neutral, and so therefore in some respects is easier to challenge because he's been very explicit about the purposes and the parameters of that kind of registry.
Sure. So let's go back to the infamous Supreme Court ruling that Korematsu versus the United States in 1944 that allowed for Japanese internment camps, because with all this talk of the Muslim registry, the specter of internment camps, has again emerged. The fact that that ruling was never overturned was described by one of the dissenting judges, Robert Jackson, Justice Robert Jackson, in 1944, who wrote, "The principle then lies about like a loaded weapon, ready for the hand of any authority that can bring forward a plausible claim of an urgent need." He had said, and in 1988, we saw President Ronald Reagan sign the Civil Rights Act and, acknowledge and apologize for what happened, and also there were symbolic reparations given to the Japanese American families who were impacted at that time. But what's to say that this ruling that was sort of endorsed by the Supreme Court under the pretext of national security will not be resurrected if there were a large-scale terrorist attack? One of the columnists in the New York Times wrote, it's one thing to disarm a weapon and another to destroy it.
Yes.
So the Supreme Court has never actually, even though it's called bad law, an anti-canon as some have described it, but it's never actually repudiated it or discredited it. So is that something for all of us to be fearful about?
Well, I think there should certainly be some concern about Korematsu lying around as this disarmed weapon, if you'd like to call it that. I think that the Supreme Court cannot, as a matter of its practice, just kind of come out and make a statement saying we made a bad decision in a previous case. It just doesn't do that, right? It's very careful to respond to the question that's in front of it. And this particular court, the Roberts Court, has been even more careful than past courts in doing this. They write their decisions in a lot of contexts very narrowly just to answer the question that's in front of them. There's actually been criticism about that they're not creating enough precedent going forward. So I would think that the Roberts Court would not say anything on this issue until it came before them, right? If there were an executive order suggesting a registration, any kind of detention camp or an internment or concentration camp, that at that point the Supreme Court could weigh in. With the composition of the court as it is, even without that ninth justice who's been missing for some time now, I still think you would have a very solid majority who would repudiate Korematsu if given the opportunity to do so. I think that, as I said, Justice Thomas is the only one who has positively invoked Korematsu as a precedent that the court should rely on. And it's come up in a couple of different contexts, even since the September 11th attacks. A number of cases have come before the Supreme Court in terms of what kind of rights the Guantanamo detainees or other detainees have in terms of access to courts and access to justice. And the court has been very careful about avoiding comparisons between that situation and the specter of a large-scale internment camp, but the justices, even in those cases, have come out on two sides. One side saying we need to be very careful of never going down that road again, and then again, Justice Thomas, alluding to that being part of the president's arsenal of powers when it comes to war making, and that when it comes to matters of national security, the court really shouldn't say a lot other than, okay, whatever you want, Mr. President. So.
I see. Okay, well, sort of moving on to this thing that you already alluded to, which is expanded surveillance, because that's another thing that the Trump, campaign and then also the transition team, I mean, they've referred to as something that might happen of the Muslim community. A lot of people don't know this, but there was a lot of this already going on under the Obama administration.
Yes.
And perhaps there'll be more sort of scrutiny among civil society groups now that it's happening, or it will happen under the Trump administration. So can you sort of talk a little bit about that? Like, what would expanded surveillance look like? And again, what kind of recourse would American Muslims have in sort of pushing back against that and preventing a more intrusive, more aggressive kind of surveillance of their communities?
Yeah, so as you said, this has been going on under both of the post-September 11th administrations thus far, right? The Bush administration engaged in a tremendous amount of surveillance, much of it warrantless surveillance, until that was exposed in 2005 and 2006. The Obama administration has also undertaken a significant amount of surveillance, theoretically under the auspices of the Foreign Intelligence Surveillance Court when it came to all of that stuff that Edward Snowden was talking about, and then also just under local law enforcement initiatives, and they're encouraging local law enforcement to surveil certain communities and then report information to the federal government. One of the disappointing things about the way the Obama administration did that was that it gave kind of a bipartisan imprimatur to this idea that this is a community that needs to be surveilled in this way, and we should go ahead and do that. And I think you're exactly right in suggesting that groups who would normally oppose surveillance of certain communities this way really did not focus their energies because it was the Obama administration doing that, which was a real shame. There were certainly certain groups like the ACLU, the Electronic Frontier Foundation, other nonprofit groups that were bringing challenges regularly, the Center for Constitutional Rights, trying to expose these kinds of practices and support plaintiffs who were challenging them. But there wasn't the same kind of widespread organized resistance to that kind of thing. And I think that this is problematic for a number of reasons, right? First of all, when you see the public fury that erupts over something like Edward Snowden's disclosures about how many U.S. people are being subject to some sort of surveillance or data gathering, there's an enormous amount of resistance. But when that is switched to, okay, well, we're only doing it for the Muslim community, but it's going to be more intrusive for them than it has been for the the U.S. public at large, there's a complete, or not a complete, but a significantly less active response to that kind of statement. And I think that there's a lot of people who don't realize the extent of what it was that the Obama administration was supporting, that there was a lot of surveillance. I mean, one of the key examples is perhaps in New York City with the New York Police Department surveilling Muslim student groups on various college campuses, not even just in New York City, but sending police officers elsewhere and then reporting their findings to the federal government. These things became exposed because of press reporting and because students were able to come forward and get support to bring lawsuits against it. So this is kind of the long background to come back to your question, which was, well, what can people do about it? I think there needs to be a tremendous amount of vigilance. I think that the Supreme Court right now is rethinking what it means to have a search and seizure under the Fourth Amendment of the Constitution, which is normally what people would use to protect their privacy in cases of overly intrusive surveillance. And I think they are, there's at least something of a percolating idea on the court of broadening the protections for individuals. Whether the case that makes that happen is one where it is a Muslim plaintiff saying, look at how I'm being targeted in this way, and it's in the name of national security, which again gives the president a lot of leeway, but it is completely unfair in how much it degrades my personal privacy. Or whether it's another type of case where another individual who is not kind of wrapped up in the national security sphere that the administration has set up, who makes that happen. I think there's some room perhaps for the court to be more protective of people's individual rights. I think there's a lot of wariness there about how much technology is used to kind of investigate people's lives and paint a picture of who they are, that kind of, you know, Justice Sotomayor and Justice Alito have both written about the fact that they feel like it undermines people's kind of humanity to be watched this way. So I hope that there will be some resistance on the court too to this idea of surveillance, but I think it again requires the will to seek out one of these organizations that can help bring a lawsuit and bring to light what these problems are. And I think that there's a combination of litigation, which is obviously as a lawyer one of our go-to tools, but also in terms of marshaling political will. And this might be easier to do in the Trump administration than it was in the Obama administration, to get groups to say, we will resist this idea that a certain population will not be afforded the same constitutional rights or human rights as the rest of the population simply by virtue of their religious background. So
so civil society mobilization and political mobilization.
Yes, and legal mobilization.
And legal mobilization, of course. Professor Setty, you've given us so much to think about, and unfortunately we're out of time, but this is really tremendous information as we go forward and sort of prepare for the future. So thank you so much for your time.
Thank you for inviting me.
Thank you. And this is your host, Mahlika Samdani. Until next time.